Hey everybody, welcome to another lecture for business law. Let me run through a couple announcements just to get you kind of caught up to speed and help you kind of see where we are in the grand scheme of things. And I'm going to make some important, well, I'll just make this announcement right now. I'm going to try to get these lectures out very quickly. Right now it's March 16th, Monday, March 16th. Classes don't officially resume back up again until Wednesday, but I want to get the lectures kind of taken care of in the next couple days and post them. The reason I want to do that is this will allow you to just finish this class. I'm going to open up all the remaining exams as well as the study sessions for basically everything that you need. You could technically wrap up this class this week. The reason I'm doing this is I've been speaking with a lot of you are leaving. A lot of you are going home. A lot of you have other things going on, family issues as well. And I want to be as accommodating as possible through this really unprecedented semester. So, like I said, I'll post the lectures, and then what I'm going to do is still give opportunity for us to have basically live study sessions or question and answer periods. I don't really know what I'm going to call them yet, but I'll probably hold those at least once a week during your assigned class time. And that will be on Zoom. I'll send you out a link so that you can just click on it, you join, I get to see you, you get to see me, and we can talk about these things. But again, that's coming. Right now I'm focused on the lectures. Okay, so again, I'll open up all of those dates. You do have one more brief due the end of this week, but that's your last brief unless you want to do the extra credit brief, but we'll talk about that too down the road. Exam 4 is normally that would have ended on Saturday night, but because of all of this, I'm keeping it open until Wednesday the 18th at 11:59 p.m. So far, about half of you have taken the exam. The exam stats are pretty good so far. You're averaging about 84%. And so that's great. I won't talk about the exam since, like I said, half of you haven't taken it yet. But that's still on the table. Now after this, this week, week 11, and next week, week 12, these are my business entity classes. So we are going to be talking about how to choose a business entity, how to start it up, considerations to think of, and yeah, the mechanics of it. That, and then we'll have the exam for that, the 27th and the 28th. So that's the end of week 12. Week 13 is my last and important lectures. I will be talking about, get rid of that. I'm going to be talking about business taxes in more detail. So it's a lot of tax planning and then wills. And I think all of those are going to be very important. So that's what I'm looking at right now. Let's see, I think that's everything that I needed to talk about right now. So I'm going to share a new screen with you. Okay, so now you can see this screen with business entities on it. So let's start that lecture. All right, I don't know what that looks like. I'm just gonna keep that small. All right, so business entities tends to start with a discussion about sole proprietorships. As you know from the reading, sole proprietorships means you didn't start any business. You're just meaning you didn't start a business entity. You didn't register a business entity. You're just running a business on your own. Again, a sole proprietorship means just that. It's one person. If you have two people, it can't be a sole proprietorship. So this is simple because you don't have to really do anything. This is what my kids do every time they go out and start or open up a lemonade stand on the corner, although I did help them register an LLC for that. But most kids, they'll just do a sole proprietorship. They'll just open up a lemonade stand, start selling it, pocket the cash, and go on with their life. Okay. What this means is, yeah, if you as a sole proprietor make money, you will take that income and then you'll report it yourself when you file taxes for that tax year. So if it was income generated in 2019, then you are going to report that on basically on your tax statement when April of 2020 rolls around and you file your taxes. That's when you'll report all of that, and you will then pay taxes on that income generated during the year. Now, the catch here, the key is that a sole proprietorship lacks many of the protections that the other business entities that we will discuss this week that they have, liability protections and tax issues, etc. So this is on the exam. This is a test tip, your first test tip for exam 5. If you see an answer, if you're going through a question and it gives a hypothetical about a certain individual that is starting a business, is deciding between a partnership, an LLC, a corporation, and a sole proprietorship, I want you to know that sole proprietor is never the answer. This is a horrible business decision usually, and at least for my purposes, I'm just never going to make it the right answer, even if it looks like it's going to be. I say things like, if you're up here looking at at my slides again, saying something like, this person is lazy and they don't want to register anything, and it's just a simple business, what should they form? Just know that sole proprietor is never going to be the right answer for that. Now, that being said, 2/3 of all US businesses are sole proprietors. These are individuals that are just running a little business out of their house, a side gig, etc. Okay, it's just not what they should be doing. So, and we'll talk about why that is. Let me jump down to this next slide. Here's really kind of the only benefits. It's easy to do because you don't have to do anything. You don't register anything with the state. You just start selling things or products or services. Now, there are disadvantages. Your personal assets are at risk because there isn't liability protection with a sole proprietorship, meaning you can't keep your business and personal assets separated. This is and anyway, the second bullet point is important too. There's a lack of business continuity. It's a sole proprietorship, meaning that when you die, the business dies with you. It ends. Now, the example that I give here is this case called Quality Car and Truck versus Sark. This was an interesting case because it involved a lumber hauler, much like the picture that you see on your screen. And Sark worked as a driver of this lumber. Oh, geez. My lights are going to go out. There we go. And because it's a case, that he was involved in an accident and injured somebody. Now, when he did that, what happened is the individual that he injured sued him. And he, as a sole proprietor, had his business assets as well as personal assets, including like a vacation property. And what he tried to do to get out of that liability was he sold that vacation property to his son for $5. Now, you don't even have to have been in this class for very long or have done the reading to know that that's a fraudulent transfer. That's going to be unwound. And yet that's what he thought was his best bet to protect his personal assets, was like, maybe I just offload them to my kid. And then the person that I injured when they sue me and get a multi-million-dollar judgment won't get access to my vacation property. Well, obviously it didn't work. And as a result of him being a sole proprietor, when he was sued, yes, he lost the business assets, including the truck and everything else, but he also lost personal assets, including that vacation property. So this is kind of the key, that there's a lot of risk with operating a sole proprietorship. And it's mostly that it's your personal assets are at risk of being taken to fulfill the judgment against you. Okay, so that's sole proprietorships. Don't do that. All right. Um, I put in a slide, two slides here about franchises. This is another type of business entity. I'm not going to spend too much time on it because franchise agreements tend to be fairly uniform. And you're familiar with franchises. If you wanted to open up another McDonald's, like if two wasn't enough for Rexburg, let's say, then yeah, you would apply for a franchise. You get a franchise agreement. It requires some money up front, and then and kind of the benefit here is that if you open up a McDonald's, there's like a 99% chance you're going to make some money. Um, and so really you get the benefit of corporate McDonald's expenses and expenditures for marketing. You don't have to go put out ads. You don't have to put commercials together. That's all taken care of by McDonald's corporate. All your job is to do is to maintain quality, which is a relative term here, McDonald's level quality for their products, and you get to continue to operate that franchise. It's a contract is what this really is. It's basically, and you understand this now after going through the intellectual property discussion last week. And that is, you can license your intellectual property. You have a copyright, license it to somebody else that's really good at making those books or getting your music out or whatever it is. You can do that with intellectual property. You can do that with businesses. We call that license a franchise agreement. So you're just basically licensing out your business. So that's kind of the key there. All right. Types of franchises, again, you got distributorships, chain style, and manufacturing. Anyway, that's all, I think, fairly self-explanatory. So let's jump into partnerships. Now, this is, I think, where the main focus of this unit starts. And just so you know, we'll kind of go over partnerships, then we'll move on to LLCs, and then we'll wrap up with corporations. And that's really it for the exam. So partnerships, if we start out with partnerships, I think a key thing for you to remember is that much like sole proprietorships don't have any liability protections, neither do general partnerships. And let me explain. A general partnership is an agreement between two or more people to operate a business. That's the definition of a partnership. So again, let's say that I'm going to start a sole proprietorship, as ill-informed as that may be, selling hot dogs on BYU Idaho campus or something. Well, if I just do that and I don't register anything, well, I've got a sole proprietorship. Now, if I ask my friend, let's just say Brother Labaugh, whose office is right next to me, I ask him to work with me. I take the east side of campus, he's going to take the west side, and we're going to sell hot dogs on campus. And we don't register anything. Well, we can't be a sole proprietorship because it's, English means something. Sole proprietor means one person. So once I have Brother Labaugh helping me out, well, now we have a partnership. A general partnership is what we call it. And it's the equivalent. There's no liability protection. If one of us does something to injure somebody on campus, like we throw a hot dog and it gets lodged in somebody's ear or something, like causes some injury, well, I can be sued. My personal assets are at risk. And if I did it, but also, here's the crazy thing, Brother Labaugh can also be personally liable for my actions because, well, we have a general partnership. There's no liability protections involved in that. And so both of our personal assets are at risk for the other person's negligence or wrongful activity. All right, key, very important. And test tip, if on the exam or anywhere I just say partnership, then you need to understand that means general partnership and there's no liability protections, no registration with the state, etc. Okay, so that's going to be very, very, very important. Now we'll get into other types of partnerships here in a little bit. We'll talk about limited liability partnerships and limited partnerships. But for those to, and there is liability protection for those types of business entities, but for that to be the case, I have to say it's a limited partnership or a limited liability partnership. If I just say partnership, you need to hear general partnership. That's what you hear in your mind. Okay. All right. All right. Let's work through this. So again, partnership, like anything else, this is contractual. It can be, it can be from an agreement. It can be express or implied. Again, two or more persons. And by the way, corporations by definition are considered persons. So watch for that as well. So two corporations working together can have a general partnership. Interesting there. So again, these in the second main bullet point, it's got 3 sub points. You look for this, like, do they say that they are going to share profits and losses? Is it going to be jointly owned? It doesn't have to be 50-50, but is there joint ownership of the business and equal rights to be involved in the management of the business? So does everybody have the right to be involved at some extent in the business itself? If you've got those 3 things, you've got a partnership. You maybe didn't even mean to form a partnership, but if you have those 3 things, then courts will say that you've got a partnership. Now, that comes with the caveat of this last bullet point on this slide. Courts will not assume a partnership if profits are shared to pay off a debt. For example, let's say that let's say that you lent me $1,000 so that I could get my law firm's marketing plan off the ground. All right. If that is the case, then I will want to pay you back. And so maybe I tell you something like, cool, thanks for the $1,000 loan. I'll pay you back $200 a month from the profits of my firm until you've got your $1,000 back plus interest or whatever. Okay, so if we do that, then we don't have a partnership. It's just me paying you back a loan, even though it kind of looks like a partnership, right? I'm saying I'm going to share with you my profits by paying you $200 a month until it's all paid off. But you don't really have joint ownership and there isn't joint management. So therefore, we're going to say that's just a loan. That's not a partnership. Same with wages paid to an employer, rent to a landlord. Like, just because you pay rent to your landlord doesn't mean the landlord has ownership in your partnership or whatever the case is. I think that's fairly obvious. Okay. Like I said, that last week, week 13, is when we're really going to focus on taxes. But it's important that you understand taxes now. And here's kind of an introduction to this. Partnership tax is classified as pass-through taxation. Here's how to understand this. You and I have a partnership. Let's say that you and I are selling hot dogs on campus. Now, at the end of the year 2020, so this current year, we've got the partnership, and throughout the rest of the year, we make $100,000. All right, assuming that we're 50-50 partners, then what happens is at the end of the year of 2020, we are going to fill out certain tax forms that say that the partnership itself made $100,000. And then it will list the partners as well as their ownership share, and will allocate the profits. And this is important. You have to understand that you report the profits, not the total income. Well, there's a caveat there, but for our purposes, let's say, so we report the profits, and in doing so, again, the profit is $100,000 from selling hot dogs. If you and I are 50-50 partners, then the partnership form will say Michael Hales gets $50,000 allocated to him, and then you get $50,000 allocated to you. That's the K1. Now, using that, then we'll get forms that go to me and to you saying you received $50,000 in taxable profit during the year, and then you have to pay taxes on that. So in 2021, when I'm filling out my tax forms, that's when I'll say that I received that profit. Okay, of $50,000, and then I'm going to pay taxes on it, as will you. Taxes will come. So what this means is that the entity itself doesn't pay a tax. The partnership, our hot dog partnership, does not pay taxes. Rather, it's just a conduit through which the money flows to the partners themselves, you and I in this case. Okay, so again, 50 to you, 50 to me. The partnership, yeah, it fills out a form, but the partnership doesn't pay tax. The tax is paid by the individual partners, you and I can't stress that enough. So some of you have this, others of you may need to like rewind and go watch this again. But in any case, that's what's going on here. So, all right, so let's move down here to formation of a partnership. Um, okay, under Idaho and pretty much every state now, a partnership can be formed either through an oral agreement, through a written agreement. It can be implied, it can be expressed, just like any other contract. That's how to look at partnership. Partnership formation. Now, articles of a partnership, this is what we call, this is the agreement that governs how the partnership is going to be run. All right, it is quite simply, if we were talking about a corporation, I would say that this is the bylaws, right? But in a partnership, we don't call them the partnership bylaws. That's silly. That doesn't make any sense. So we call it the partnership the partnership agreement or the articles of partnership. Those are two interchangeable things. Okay, and then I just had to do this, the partnership by estoppel, because you can have this, and kind of the key case here is this one at the bottom: best cartage versus Stonewall packaging. Now, let's just go to this slide. What happened here is, yes, these are companies in the South. If you're wondering how weird it is it that two companies working together? One is called Jackson, and the other is called Stonewall. Well, these are important military figures in the South. And what happened is Jackson Paper Manufacturing, it makes paper products, and then those paper products are used by Stonewall Packaging. So Jackson and Stonewall, their officers and directors, or managing partners, are the same for both companies. They kind of operate out of the same offices. Everybody's the same for these two different companies. So Best Cartage is a trucking company, and they agreed to basically ship a number of Stonewall's. Is it Stonewall? Let me just make sure I'm getting this right. Stonewall's products. And now Stonewall was kind of this new partnership, this new business entity. But they knew that Jackson Paper was a large company. And so when Jackson said, yeah, we're working with Stonewall, sell their product or move their products and you'll get paid. Well, they did. They shipped all of these products. And then Stonewall, the new company, said, oh, I'm sorry, we don't have money to pay you for shipping all of our products. Sorry. Well, at that point, Best Cartage sued not only Stonewall, but also Jackson, and basically used the estoppel agreement, saying Jackson told us that they had a partnership, essentially, with Stonewall. Jackson and Stonewall were basically this partnership working together. And if that's the case, if they are a partnership, then they're both liable for the breach of the other. Meaning, so when they went to Stonewall and said, pay us your money, and Stonewall said, sorry, we can't pay you, then all the Best Cartage had to do was establish that the two were working as a partnership, and then they could sue Jackson, who had lots of money, and that's how they ended up getting paid. So remember what estoppel is. Estoppel is just that idea that you lie, or usually you lie and say, we're a partnership, but you're not. Well, then when the other party breaches, you can't later say, sorry, we're not a partnership, just kidding. Like, haha, you are stopped from saying that. That's the whole purpose. I got to get my hand out, like, you are stopped from saying that. So that's the estoppel agreement there. All right, so now we get into the rights of the partners, meaning you're one of the owners of a partnership. You and I are selling hot dogs, right? Well, if you and I are the owners, we may bring on employees, but you and I are the owners. We're the ones that have a 50-50 partnership agreement. So I own 50, you own 50. Here's the deal. In a general partnership, all partners have equal rights in managing the partnership. This is a general rule, assuming that there's no partnership agreement that says anything different. You and I have a 50% vote, and you have a 50% vote when we're making partnership management decisions. All right. Interest in the partnership. So what that means is, and this gets good. Well, let me give you a hypothetical so that you understand this. Let's say that you and I start a partnership. Chances are I'm more established than you are, so I have more money to put into the business. So let's say I put in $100,000 into our hot dog partnership, and you put in everything you have, $10, right? So I'm putting in a whole lot of money, and you don't put in that much at all. Well, if we don't have a partnership agreement, meaning an agreement between us about how we're going to share profits or how we're going to manage the company, then it's a 50-50 partnership. You're getting a great deal. You put in hardly anything into the business, and yet you are a 50-50 partner. And so next year, when the firm makes $100,000, you're going to get 50 grand and I'm going to get 50 grand. And you think that's kind of harsh. Like, maybe you feel bad for me, right? Because you know that I put in a lot of money and I want my money back. I want my investment back. Well, if it's not in the partnership agreement, it doesn't matter. You get 50% of the proceeds or losses of the business. Okay. Now, as far as compensation, you'll see that you'll see that this carries through to the other business entities as well. But with compensation, you may say, like, I'm a 50-50 partner, and like, let's say this is you. Dang it. Wave until my light comes back on. You may say I'm a 50-50 partner, therefore I'm entitled sorry. You and I are 50-50 partners. You work a lot and I don't work that much. Well, you may think, like, because I'm working more, I'm entitled to a greater share of the profits, which you're not, by the way, you know that from what I just said. But then you may think, well, I'm working a lot. I should be paid an hourly rate or something like that. Nope. If you're a partner in a partnership agreement, your payment is just your profit interest, your proportional profit share. And so again, it means don't get a lazy partner, because if you have a partnership and you are both working, well then, yeah, that's great. But if one partner becomes a slacker and stops working, the partner is still entitled to a 50% ownership share, unless he or she starts like doing things to actively damage or injure the business. Then that's a different discussion. But assuming that the person is just lazy, well, that's your fault for going into a partnership with that individual. Okay. All right. So moving on, we've got the duties of the partners. So a lot of this you're going to remember from agency. If you're a partner of a business, well, then you're an agent of the business. And so that's why we've got a lot of these duties that are going to come back. And first, we start with the fiduciary duties. Remember, fiduciary typically deals with some type of responsibility for an accounting or money of the business itself. So let's start with kind of the subset here, the fiduciary duties. One, you have a duty of care. Now, read this carefully. It means that you as a partner, remember, you and I have a hot dog business partnership. It means that you have to refrain from grossly negligent or reckless conduct, intentional misconduct, or knowing violation of the law. Good gracious, that's a low standard. I need you to understand, like, when you are a partner, it doesn't mean you have to be awesome. It just means you can't super suck, is what this means. Like, you can't be gross. You can be, and get this means you can be negligent as a partner. You can be negligent. You can make lots of mistakes and screw up. You just can't be grossly negligent. Pretty interesting. We'll come back to this one. You'll see this kind of go throughout the rest of the semester. Now, the duty of loyalty is important. If you and I have a hot dog partnership, it means that you can't start another hot dog business that competes with our business. That makes sense. Like, you have that duty of loyalty to me and to the business that we own. So again, you may get a great offer from like J Dogs or something to open up a franchise here in Rexburg. Cool, congratulations. You just have to say no because you're already in a partnership with me. Now, yeah, you can end our partnership, and that's fine, usually. But yeah, it just means you can't, while our partnership exists, you can't compete with me. All right. So yeah, that's kind of where we start with these duties, and this is a great example of a partnership gone bad. What happened in Meinhard versus Salmon? Look at the date here. This was kind of timely given the current economic environment that we have today. I think the stock market's down another 10% today. Again, this is March 16th. Good gracious. But here we've got the roaring 20s, right? 1929, things are great. New York is hopping. Well, Salmon and Meinhard, these are the last names of two men that had a partnership. And they had this, basically a hotel. So they had a lease for this hotel. And Salmon brought on Meinhard to be his partner to kind of update this hotel so they can make money off of it. Well, right before the term ended, kind of right before the partnership ended, but the partnership still existed, Salmon got an offer to basically break the lease and have him work to build, to basically take down the hotel and make a new high rise. So again, New York was big in the 1920s, but the high rises weren't totally taken off yet. So he gets this opportunity to basically kind of become a partner in this new high rise building. And so he did it. Salmon did it, but he never told his partner, Meinhard. Meinhard finds out about it and sued. And it turns out that, to answer this last question on the slide, yes, Salmon breached his fiduciary duty. Why? Because this was a big business opportunity for him, and he should have involved his other partner who had an interest in that property at that time. And so, yeah, he breached his duty of loyalty. And as a result, Meinhard was able to get a piece of the action here with the new high rise and the new lease that was converted. Okay. All right. Liabilities of partners. This is important. You and I are partners. Well, great. There's a catch. You're liable for my screw ups and I'm liable for your screw ups. That's like the good comes with the bad, or I should say the bad comes with the good, right? Like, yeah, we get to share in profits, but we also have to share in losses and liabilities. So all right, so this is what this all means. You and I, remember, when I say partnership, remember, you hear general partnership. You and I have a general partnership. If the partnership suffers a loss, you and I suffer a loss. Like, we share in those losses as well as the profits. Now, this second term is important, joint and several liability. What this means is that, let's say that the partnership injures somebody, or one of us injures somebody in the course of the partnership duties. We're selling hot dogs. We've got a little hot dog cart, and we accidentally bang into somebody's car. And it's President Irene's car. Well, okay, President Irene probably wouldn't sue us, but let's say some mean teacher or something on campus, and we run into their car, and the partnership gets sued and owes $20,000 to repair this super expensive, apparently, car's paint job and body work that we caused when one of us rammed the hot dog cart into a car. Okay. Well, what that means is that the person that was injured can sue the partners. This is what I'm telling you is what joint and several liability means. It means they can sue the partnership. They can sue the partnership and me. They can sue the partnership and me and you. They can take their choice. Whoever's got the most assets, just going to join them all in the lawsuit and then collect from whoever later. If they know that you're the student and you've got $10 to your name, well, they probably aren't even going to bother joining you to the lawsuit. It'll probably just be the partnership and me. But again, that's the risk that you run with a partnership. And again, it could be that you're the one that ran over a student or hit a car or did whatever that caused the injury and is the reason that somebody's suing the partnership and me. Well, that's the risk that I run by having a general partnership. I don't have any personal liability for your actions, for your wrongful actions taken in the course of this whole thing. So again, that's joint and several liability. All right. Okay, so now we get into the slides dealing with how do you get out of a partnership, right? Okay, so again, this slide I think is what will help you a great deal. There are certain events that just cause dissociation. Now it's not disassociation, it's just dissociation. Okay, that's important. Okay, so you could just say, I desire to withdraw from our partnership, and then I can be out of the partnership. All right. It's basically me breaking up with you. I'm sorry. I like come to you and I say, it's not you, it's me. I'm just done being your partner. All right. Once that happens, I can get out of the partnership. Now all of this is assuming that there isn't a partnership agreement that says anything to the contrary. If the partnership agreement says that you can't do that, well, then you can't do it because it's a contract. But again, most general partnerships don't have a partnership agreement, so a lot of this slide applies. All right, an occurrence agreed to in the partnership agreement. So let's say that we do have a partnership agreement, and it says something to the effect of like, our partnership will end on March 17th, 2020. Well, that's tomorrow. And as soon as tomorrow comes, our partnership is dissolved. Dissociated is the other word. This third sub-bullet point is the saddest one of all. This is like, let's assume there's 3 partners and 2 of us get together and decide you're not a partner anymore. That's what this is like, you're getting voted off the island situation. That's what this means. So yeah, and again, this assumes that partnership agreement doesn't say anything to the contrary, but again, if it's silent and the other partners vote you out, you're done. And then court orders, of course. Now, the effect of this is that once this happens, once a partner is dissociated, then that partner doesn't have management rights anymore. The duty of loyalty ends, meaning they can start a new competing business. But they have a duty to report income derived during the course of like when they were a partnership. And this makes sense. Like, you may have gone out and sold hot dogs and a bunch of people said, and maybe you were just giving them out and saying, yeah, pay me later. And then I find out about this and I don't like what you're doing. So I kick you out of the partnership, me and the other partner, we kick you out. And then those other people pay you a week later for the hot dogs that they bought while you were still a partner of the partnership. Well, in that case, obviously you're going to have to return that money to the partnership. Now you'll get your share of that because that was income derived while you were a partner and you're entitled to a profit interest of that. But again, this is where lots of partners get in trouble. They'll get that money and then be like, well, yeah, screw those people for kicking me out of the partnership. I'm keeping this money. That's just known as theft. Okay. All right. Now, for 2 years after a partner dissociates, this is interesting. The partnership can be bound by like you were the one kicked out. Well, I can be bound by things that you do and for 2 years. And let me give you an example. Let's say that you are dissociated and we have a joint bank account, a partnership bank account at, what is that, Mountain America Credit Union, downtown Rexburg. Well, if you go down there and take out a loan the next day, I'm going to be bound by that. Why? Because the bank thinks that we're still partners. I didn't tell the bank that I had kicked you out. So if I don't want to be bound by this, if I don't want this last bullet point of the slide to apply, well, that means that once I kick you out of the partnership, I better go tell the bank, hey, by the way, John or Jane or whatever your name is, isn't a partner anymore. We've kicked them out. They no longer have signing authority and they no longer have any agency authority for the hot dog partnership. That cures everything. So that way, if you go in the next day to Mountain America and you take out a loan or try to withdraw money from the account or whatever, if the bank does it, well, the bank's liable for that because I told them not to do that. That's the important issue here. Okay. Termination, this just means like, so now dissociation was like kicking one of the partners out or one of the partners pulling out themselves. Termination means the partnership ends. And these are the two ways that, well, this is how it happens. Dissolution means this is the termination of the partnership itself, the disbanding of the partnership. These can be done by the acts of the partners, by operation of law, or by judicial decree. Now, this sub-bullet point here is going to be on the exam, so I think it is. Pay attention. If our partnership says that the partnership ends after a certain amount of time, well, that means that the partnership was dissolved by the acts of the partners, because our act as partners was to say it was going to end on this certain day, right? Termination by operation of law just means like we did something illegal and the law requires that the partnership end at that time. And then judicial decree, kind of same thing. A judge may decide that the partnership has done something wrong, or that it would be the right thing to do to terminate a partnership. And there's lots of reasons why they would do that, but let's not worry about that. Okay, once the partnership has been terminated through whatever process, then the winding up, this is a legal term, winding up process starts. Typically what this means is that you will liquidate the assets of the partnership. If it's you and I selling hot dogs, we'll sell the hot dogs for whatever we can get for it. We'll sell the hot dog carts. We'll sell our little square, stripe, whatever machine that we take credit cards with. We'll just sell all of our assets, and then we'll use that money to pay off any debt that we may have. We may have a line of credit with the hot dog supplier or whatever. We're going to pay that off. And then any additional assets that are left over, we'll distribute according to our ownership share. And again, if we don't have an agreement, then we're going to split them 50-50. And voila, we're done because we finished the winding up process. Okay, now we get into these other forms of partnership. The first one being a limited liability partnership. This is important because all of the main, formerly the big five, now the big four accounting firms, they're all LLPs, limited liability partnerships. Now what this does is this adds some additional protections for the partners. If you become a partner of KPMG, now no longer are you personally liable for the acts of the other partners. Okay, so again, think of it like this. You and I are both partners at KPMG, and I screw up a major account, millions of dollars worth. Like basically, I'm sending our firm down the path of Arthur Anderson or something, right? Like I screwed up with Enron. I'm cooking the books. I'm committing fraud. Well, what that means is that I am personally liable for that because I did a wrongful act, and KPMG is going to be liable for that as well. But you, as a partner of KPMG, are not personally liable. Your house, your vacation properties, your cars, all of those personal assets that you own are totally safe. And this wouldn't be the case if KPMG operated as a general partnership. Remember, all the partnership assets are at risk. So yeah, that's just what I need you to know. Okay, so that's a limited liability partnership. Now, the key here is that, sorry, I don't know what I just said, but I meant to say a limited liability partnership. Maybe I did say that. Okay, now, I was going to say something else important. It'll come back to me. So, oh yeah, here it is. The limited liability partnerships, you may think like, why doesn't everybody just start a limited liability partnership? Well, there's a big reason. And that is that most states limit limited liability partnerships to only professional occupations. You have to be a law firm, you have to be an accounting firm, you have to be an architecture firm, you have to be a doctor's office. These are like 4 of the most common categories that are allowed to be limited liability partnerships, or LLPs is what we usually refer to them as. So again, if you're just starting a hot dog business, sorry, you can't be an LLP because you're not one of those professions. So again, that's not even not an option for you. All right. Now, so what does that leave us with? Well, it leaves us with this other business entity type called a limited partnership. Now, a limited partnership means, like imagine this, like you've got the LP and owners of this are, one, you've got a limited partner, and on the other side, you've got a general partner. This is not a great option when you think about it. When you go through this slide and see that you have to have at least one general partner, meaning like let's say, again, you and I want to have a hot dog business. Well, I put in all the money and you're going to put in all the work. Well, in that scenario, I'm going to be the limited partner. I'm putting in the money, you're going to run the business. I'm the investor, basically. Now, because I'm not running the business, my personal assets aren't at risk when you take the hot dog cart and ram it into somebody's car or hit somebody or do whatever that causes somebody injury. I'm not going to be personally liable for that. Now, the business is, and all the money that I put into the business, that's still at risk. But at least I can sleep well knowing that my car and my vacation property and all of those things are safe. Why? Because I'm the limited partner. Now, what that means, though, is that I can't tell you what to do. I can't help you in the management of the hot dog business. As a limited partner, you're kept out of management. Now, the general partner, you can manage the company and you can be personally liable. Why? Because you're the general partner. That's what an LP is. All right. A limited partnership is that it requires one limited partner and, well, at least one general partner and at least one limited partner. Again, not a great thing. Like, we have better options, and those better options we will talk about in the next lecture when we get to LLCs. All right, so I'm going to end this lecture right now. After having covered sole proprietors and kind of franchises, and then really getting into partnerships, primarily looking at general partnerships, but also looking at limited liability partnerships and limited partnerships. All right. Yeah, I don't really know how to end this. Normally I just say, get out of my classroom, but now you're just probably at home watching TV. So, well, hopefully not watching TV while doing this. All right, I'm done, and I'm ending it and I'm cutting it off. All right, let me figure out how to do this. All right, see you at the next lecture.